This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why it is not fair to require a tenant to pay for damage insured by the landlord, and why there is no right of subrogation available against a tenant in Connecticut and many other states. Because for an insurer to subrogate against a tenant, the lease must require the tenant to obtain insurance for the benefit of the landlord, not just for his own personal property. In AmGUARD Insurance Company versus Tyrone and Shakyra, Ellis, the United States District Court for the District of Connecticut on November 19, 2025, Judge Janet C. Hall found that the defendant's motion to dismiss the amended complaint on the basis of Connecticut's anti-subrogation doctrine required dismissal. The key facts of the case was that Landlord Michael Caldwell, a Connecticut citizen, owned a multifamily building in Windsor, Connecticut. The defendants, Tyrone and Shakyra Ellis, were residential tenants in the building. On or about March 1, 2025, a fire started in the Ellises unit, allegedly because they left minor children unsupervised with a lighter. Damage exceeded $102,256. Caldwell's property insurer, AmGUARD Insurance Company, paid Caldwell's claim and then sued the Ellises in subrogation for negligence and breach of the lease. The lease was attached to the amended complaint, and it included a requirement that the tenants must carry their own renter's insurance for liability and for damage to tenants' property in the dwelling. The lease also had general clauses prohibiting damage, requiring tenants to repair damage, normal wear and tear accepted, and making tenants liable for costs if landlord has to make repairs. AmGUARD filed in federal court invoking diversity jurisdiction. The Ellises moved to dismiss. The court granted dismissal under 12b-6 because Connecticut's anti-subrogation rule barred the insurer's claims. In DeLuio versus Joseph, a 2002 Connecticut Supreme Court decision, a landlord's property insurer has no subrogation right against a tenant for fire or negligence damage to the leased premises absent an express agreement in the lease that clearly allocates the risk to the tenant. The court recognized the public policy against economic waste by means of duplicate insurance, and the tenants reasonably expected that the landlord's fire insurance covers the building and they will not be sued by that insurer. Essentially, the argument was that the insurance obtained by the landlord was for the mutual benefit of the landlord and the tenants. The court explained that there is no requirement that the word subrogation appear, but the lease must clearly put the tenant on notice that A, they will be personally liable to the landlord and the landlord's insurer for major casualty losses, and B, they need to obtain liability property insurance that protects the landlord and his building, not just their own stuff. To hold the tenant to the lease must require the tenant to buy a substantial liability policy explicitly for the mutual benefit of the landlord and the tenant. The Ellis's lease only required the tenants to get renter's insurance for their own liability and their own personal property, exactly the opposite of protecting the landlord. There was no language in the lease requiring insurance for the landlord's benefit or the mutual benefit of the landlord and the tenant, and there was no broad indemnification clause making tenants responsible to the landlord or his insurer. The generic terms "don't damage" or "repair damage" and "pay us if we have to fix it" clauses were held to be insufficient. Both the negligence and breach of contract subrogation claims failed, therefore, as a matter of law. In residential leases, Connecticut presumptively prohibits a landlord's property insurer from suing a tenant in subrogation for fire or other casualty damages. To overcome the presumption, the lease must contain clear, specific provisions that, 1, put the tenant on notice that they will be liable for damage they cause to the building structure beyond ordinary wear and tear or a security deposit, and 2, require the tenant to obtain liability property insurance that protects the landlord or is for the mutual benefit of the landlord and tenant, not just renter's insurance for the tenant's belonging. Boilerplate "tenant shall not damage" or "tenant shall repair" clauses are not enough in Connecticut, nor in most places. Landlords who want subrogation rights must draft or use forms that contain explicit risk allocation and insurance procurement language that satisfies the court decisions in the state. In my opinion, subrogation is an equitable remedy where an insurer has the right, after it pays a claim, to recover the amount paid to the insured from the person or persons responsible for the loss by suing in the name of the insured or in their own name. However, in a landlord-tenant situation, unless the lease requires the tenant to be responsible for the damage, there can be no subrogation because, in my opinion, insurance was taken out for the mutual benefit of the insured and the insurer, and that is why Connecticut has a no subrogation rule. This video was adapted from my blog, Zelma on Insurance, and is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week, and you'll also gain access to the more than 5,250 blog postings. If you have any interest in more detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. And please tell your friends and colleagues about this blog and these videos on YouTube and rumble.com so that they too can subscribe. They're free. Thank you for your attention.